Like in okay. What's the name of the book?
Okay, for you people who take Ronnie Young for a class, before you leave, sign up the sheet and maybe check it as a sheet here. She'll say here afterwards. Okay. So you non-CJ people don't even pay attention to that. But you're going to be tested on those sign up. You can all move up if you want to. You don't have to sit back.
Did you reserve all that?
Well, I thought there was going to be masses of people. Move up. Be friendly. I'll get right on.
May as well. It's going to be a cutting edge lecture, like my favorite science class.
Okay, so welcome to Constitution Day lecture that LSUS has been doing for 33 years because we're just really excited about the Constitution because, as you know, the United States has the oldest written constitution in the world that's still in operation. What more could you want? Did you get that? Team America has the oldest written constitution in the world. To put that in perspective, 2/3 of the constitutions have only been around since after WW2. When was WW2?
1945.
Okay, so after 1945, 2/3 of the nations in the world didn't have a constitution until then. So we have the oldest. How old is old? 229 years this year. Are you excited?
Yes.
Yes, it gets better. Because chills will start running up and down your spine, not only today when you hear the cutting edge lecture, but it'll go on through tomorrow, because tomorrow is actually the real Constitution Day, day-wise. So September 17th is Constitution Day, which should be one of the most exciting days in anybody's life if you're a part of the United States. But sometimes I have suspicions about some of you, but we don't check papers in here. So who's the father of the Constitution? This is a fill in the blank. That is so bad. James Madison is the father of the Constitution, and if you know anything about James Madison, our fourth president, he was from what state? Virginia, meaning that he was a Southerner. So the chills should start running up and down that spine of yours because he's the so-called father of the Constitution. And today we have another Southerner, our speaker from Louisiana. What more could you want? Brian Flanagan is one of the up-and-coming young lawyers in the state of Louisiana. He's an associate with the law firm in Shreveport of Blanchard, Walker, O'Quinn, and Roberts. He has his MLA degree from LSUS that he earned in 2010. Then he went to law school at LSU and got his law degree from LSU in 2013, where he served on the Louisiana Law Review and graduated magna cum laude. That's very, very impressive if you're a law student. Thank you. That's very good. And then he chaired the Shreveport Bar Association Law Week Committee in 2016. And now he's going to, this morning, give us a spine-tingling James Madison type of PowerPoint presentation on the greatest Supreme Court decision in U.S. history. Flanagan.
Thank you, Dr. Peterson. Always sounds more impressive when someone else reads it, so I appreciate that. It's an honor to be here. I want to thank everyone for being here. I realize that it's early and it's a Friday, and that you'd probably rather be somewhere else. But at any rate, thanks for being here. As Dr. Peterson mentioned, I'm a former student of his. It wasn't that long ago that I was actually sitting where you are. I remember attending the Constitution Day lecture when I was a student. So it's an honor to be asked to come back and present the lecture. I had originally about an hour or so. I shortened it down to about half an hour, so hopefully that will do well today. The topic today is Marbury versus Madison, the most important Supreme Court case in Supreme Court history. How many people are already familiar with Marbury versus Madison? Okay. Well, what's interesting about the case is not just what happened in the case, not just the legal issues, but the historical context of what was going on at the time that the case happened. So when I say it's the most important case in Supreme Court history, you might be wondering why. And rather than tell you right now, I want to wait till the end because I want to first put the case in its historical context, which, like I just said, is in many ways is just as interesting as the legal issues in the case. So starting with that, I want to introduce some of the main characters. If I can get my PowerPoint. First one is John Adams. John Adams had been elected president in 1796. He served 2 terms as vice president under George Washington, and then in 1796 he's elected president. And his vice president at the time is our second character of Thomas Jefferson. What's interesting about this is that the election of 1796 was a contested election, and under the system that we had at the time, whoever got the most electoral votes was the president. Whoever got the second most became the vice president. So even though they ran against each other, they wound up as president and vice president. And we don't have that system anymore, of course. I think the founders didn't realize that the impact of political parties that we have, so we did away with that system. But that was what we had at the time. So Jefferson was serving as vice president for Adams, and they were rivals. They had different ideas about how the country should be run and what the country was going to look like. And if you remember, at this time the country was really still in its infancy. We just had our first president, George Washington, and so we're now on to our second president, John Adams. But there's still very differing ideas of what kind of government should we have. What are going to be the boundaries of power between branches of the government? And so that is all still very much to be determined what that's going to look like. John Adams was what was called a Federalist at the time. Just to very briefly summarize, Federalists believed in a strong central government. Jefferson was more of a states' rights guy. So anyway, that's sort of the backdrop for the election of 1800. In 1800, John Adams is running for re-election, and he's running against Thomas Jefferson. This is in that way, it's a rematch of the 1796 election. It's also interesting to think about its sitting president is being challenged by a sitting vice president, which I think wouldn't normally happen, but for the system that was in place at the time. So it's a rematch of the 1796 election. Another candidate in the race is a former senator from New York named Burr. You probably heard of him. He's famous in American history for reasons beyond the scope of our lecture. But anyway, he was another candidate. And as the result of the election, Adams loses. And Congress is swept out of office. But what's interesting about that election is Jefferson and Burr were tied. They each had the same amount of electoral votes. So what happens in that case is that it goes to a vote from the House of Representatives. And it's the House of Representatives who gets to decide between Jefferson and Burr who will be president. Now, the interesting thing about that is that this is the House of Representatives that's now a lame duck Congress. They've been voted out. They're really Adams' allies. They're mostly Federalists, and they really don't like Jefferson. But here they are tasked with choosing the president between Jefferson and Burr, and they really can't decide. It goes on, ballot after ballot, where they're still stuck in a tie. And these ballots aren't happening one after the other. It's days and weeks going on where we still don't have a president while they're trying to figure that out. Finally, it goes 36 ballots before Jefferson finally prevails. And so he is the president-elect. He's due to be sworn in March of 1801. And Adams knows that his time in the government is limited. Now here's a good time to introduce the next character, John Marshall. John Marshall was the Secretary of State under John Adams. But he also, at this time, is going to be appointed Chief Justice of the Supreme Court. As Adams is running out of time, he's got just a few months before he's going to leave office. He appoints John Marshall as Chief Justice. This is January of 1801. The Senate confirms him. He takes office in February of 1801. And for a time, he is serving as the Chief Justice of the Supreme Court, and he's also still the Secretary of State for Adams. He's got both offices at the same time. And that's going to be an important fact in the case, as we'll see in just a few minutes. Adams actually asked Marshall to still stay on as the Secretary of State, finish out the term. It was only going to be a few more months, so he agreed to do that. One last thing to mention about Marshall, he's second cousins with Thomas Jefferson. We know Thomas Jefferson is about to come into office. Second cousins with John Marshall. They also have differing views. Marshall is a nationalist. He was at Valley Forge with George Washington. And like I say, Jefferson is a states' rights guy. So even though they're cousins, they've got differing views. And that's going to become a factor later. But anyway, that's John Marshall. Meanwhile, Adams knows that he's about to leave office. The Federalists have been defeated. They've been swept out of Congress. He decides that the judicial branch is going to be the last stronghold of the Federalist Party. And his plan is that he's going to fill the judicial branch with as many of his allies, as many Federalists as he can, and try to prevent Jefferson from taking what he believes is the wrong direction for the country. So that's what he starts doing. Congress creates some new judgeships. He starts appointing his own people to fill those judgeships. Meanwhile, Jefferson isn't happy that this is going on. He's getting ready to take office, and he sees that Adams is already setting it up to have Federalists in there that are going to slow down his agenda, get in the way, and so he's not happy that any of this is happening. But at any rate, Adams is appointing judges, trying to fill up the judiciary, like I say. Some of those appointments are for the District of Columbia, which has just been created at this time. Now, Adams signed some commissions, appointing some judges, and they're sealed, but they don't yet get delivered. And we've all heard that phrase, signed, sealed, and delivered. That's what needed to be done for a judge to take his commission. He needed to take office, he needed to receive his commission. Adams was up to the very end of his term signing these commissions. They were trying to deliver them, and they just simply ran out of time. And there was a couple of commissions that just didn't get delivered. And what's interesting is that it was the Secretary of State's job, who, remember, is John Marshall, also now Chief Justice of the Supreme Court, to see that those were delivered. Anyway, they didn't get delivered, and that's going to become the basis for the case. One of the commissions that wasn't delivered was for Marbury, who was supposed to become a justice of the peace in the District of Columbia. That's going to become the basis for this case, Marbury versus Madison. Okay, so like I said, the commission wasn't delivered. Adams is now out of office. Jefferson is sworn in as president. He goes to the State Department and he sees that there's some commissions that haven't been delivered. And he says, don't deliver those commissions. Now, Jefferson was very familiar with how the Secretary of State's office worked. He was the Secretary of State under George Washington. So he knew what was going on. He said, let's not deliver those commissions. He considered them void because they weren't delivered. And really, if he had an opportunity to prevent some of Adams' guys from becoming judges, he was going to take it. So he instructed the Secretary of State, who was Madison, not to deliver the commissions. So fast forward to December of 1801, Marbury and 3 others filed a lawsuit to seeking an order for their commissions to be delivered. And that's the case, Marbury versus Madison. So Marbury petitions the court for an order ordering Madison to deliver his commission. The suit is filed in the Supreme Court, which when you think about it is kind of interesting. Normally a case is filed in a lower district court. It's then decided, it goes up to the Court of Appeal, then finally it goes to the Supreme Court before they hear it. A lot has already been done. But this case was filed in the Supreme Court. It started in the Supreme Court. And that's kind of rare for that to happen. And if you're wondering why that happened, there was a statute that Congress passed, the Judiciary Act of 1789, and that purported to expand the original jurisdiction of the Supreme Court really beyond what Article 3 set out. But you could read it in a way that said you can bring this case in the Supreme Court. So that's what Marbury did. That's how it wound up in the Supreme Court. After the case is filed, the Supreme Court sets what's called an order to show cause, ordering Madison to come to the court and explain himself, basically explain why this commission wasn't delivered. And really, when they're ordering Madison, Madison is just doing what Jefferson is saying. So it's really through Madison, they're ordering Jefferson to come and explain himself. And the idea that the court is ordering the president or the Secretary of State to come explain himself is kind of an interesting idea. Like where do they think that they have the authority to do that? And now that's a good point to mention that at this point, the court is very, very weak. It doesn't have any respect at all, nothing like today. It doesn't have any of the same prestige that it has. Definitely was not seen as a co-equal branch of the government. The Supreme Court really didn't even have a home. When D.C. was established, of course, there was the White House was being constructed, the Capitol was being built, but really nowhere for the Supreme Court to meet. There's not the big court that we all recognize today. And the Supreme Court was just meeting in a small committee room at the Capitol. They didn't even have their own building, and really nobody even thought that they really warranted their own building at that point. You also might remember that John Jay was the first Chief Justice of the Supreme Court. He actually didn't think it was that great of a job. He resigned, he left, because he would rather be governor of New York. So, really that would never happen today, but at the time that just gives you an idea of kind of how little people thought of the Supreme Court. But here's the Supreme Court asserting themselves in this case, ordering Madison to come explain himself for why this commission has not been delivered. What's also interesting about this case is that because John Marshall was the Secretary of State, he's really a fact witness in the case. he would know whether or not this commission has been delivered, which is an important part of whether or not Marbury is going to be able to prove his case. So Marshall really is going to be a witness. The idea that he's also the Chief Justice, by today's standards, you would think that that creates a conflict of interest. John Marshall probably should recuse himself from hearing this case. But nobody really thought of that at the time, so he didn't recuse himself. He heard the case. But that's an interesting fact to point out on that. Jefferson and Marbury think so little of the court in the case that they don't even respond. They just ignore the court and say, we're not even going to dignify this case with a response. Normally in a lawsuit, you file an answer, you at least show up and present your side. They didn't do any of that. That, again, shows just how little they thought of the court, that the court was weak and effective. We're not gonna bother with this. So they have a trial. The trial takes 2 days. Like I say, Jefferson and Madison, they don't even show up. Now the court goes to work deciding what to do in the case. And for Marshall, it's kind of a no-win situation. He thinks he's got 2 options. He can either rule that Marbury is entitled to his commission and try to order Jefferson and Madison to deliver that commission. But there's some problems, there's some risks if he does that. First of all, it might be seen as a political move, sort of the Federalists against the Jefferson Democratic Republicans. There's also the risk that Jefferson would just ignore the order. And he could say, well, you can order me if you want, but I'm not going to do it. And that would run the risk of confirming that the Supreme Court was weak, ineffective, didn't have any power. So he really thought, I'm not sure if I want to take that risk. On the other hand, if he said that Marbury wasn't entitled to the commission, he runs the risk of being accused by the Federalists of, well, you just caved to the political pressure, and his own party would alienate him and vilify him. So it seems like no matter what he does, he's going to upset people. But what he ends up doing is really a brilliant move that, and this is why the case becomes the most important case in Supreme Court history. When the opinion came out, and I just want to mention it came out 13 days after the trial, which by today's standards would be record time. Normally it takes months, sometimes even years, for a court to come out with an opinion. 13 days was very quick, but at the time it seemed like a long time. But when the opinion came out, John Marshall really phrased the opinion as asking and answering 3 questions. The first question he asked was, does Marbury have a right to his commission? And he said, yes, he does. The commission should have been withheld after it's signed by the president. It's valid. Just the act of delivering it to him isn't one of the steps of whether it's valid or not. And so he is entitled to his commission. The second question is, if Marbury has a right and that right was violated, does he have a remedy? And Marshall said yes. Now at this point, it sounds like he's setting this up to order Jefferson and Madison to deliver the commission. And so everybody is sort of waiting for that. But what he does instead is really the brilliant move of this case. The third question he asks is, if the law provides a remedy, was the proper remedy to bring this case in the Supreme Court? And to that question he says no. And that's kind of a surprising result, because Marbury thought he was relying on this statute that said he could bring this case in the Supreme Courts, but here's Marshall saying that he can't. And the reason is Marshall declares that statute is unconstitutional. The reason that it's unconstitutional is because that statute purports to expand the court's jurisdiction beyond what is set out in the Constitution, beyond what's set out in Article 3. And because it conflicts with the Constitution, Marshall says this statute is unconstitutional. So the short-term result, Jefferson sort of wins the case because Marbury doesn't get his commission. And it's kind of weird to say that he won because he really didn't even participate in the case. But at any rate, there's nothing for him to be upset about. He doesn't have to give the commission to Marbury. There is the language in there that Marbury was entitled to his commission. So even though Marbury technically lost, it's a consolation that the court is saying, you are entitled to this commission. So he's really not that upset either. But the long-term thing that happened in this case is what's most important, in that ruling that a statute is unconstitutional. John Marshall is announcing that the court has the power of judicial review. That's the power to say that a statute conflicts with the Constitution, and because it does, it's unconstitutional. Now, before this time, the court had not done that. It wasn't clear whether the court had this power. Marshall didn't come up with the concept of judicial review, but it was in this case that he announced the court has this power. And that's when he delivers the famous line that it is emphatically the province and duty of the judicial department to say what the law is. And as we'll see in just a second, that line has been cited by the court over and over and over as the basis for the power for many decisions in the future for it to do what it did. Really, in a nutshell, that is why the case is so important, is it because it establishes that the court has the power of judicial review. And what that does is that it establishes the Supreme Court as really a co-equal branch of the government, which before this time, like I say, was really not the case at all. It establishes the power of the Supreme Court. This foundation for the power of the Supreme Court really becomes one of the key checks and balances in the system of separation of powers. And this is all happening at the context, like I was saying at the beginning, of we're still deciding what kind of government we're going to have, what kind of where's the power going to be allocated. And so for Marshall to announce that the Supreme Court has this power really helps frame how the government is going to look going forward. And this case has been cited many times by the Supreme Court. Just to name a couple cases, some semi-recent cases. One is Griswold versus Connecticut. If anyone's heard of that, it's the case where the Supreme Court said that the Constitution protects the right to privacy. And in saying that, they cited Marbury versus Madison, saying, we are the interpreter of what the Constitution means. And they're relying on that to say they found it protects the right to privacy. It was also cited in U.S. versus Nixon. That was the case that related to the Watergate scandal, some of the tapes or transcripts that Nixon had. U.S. v. Windsor, which is the same-sex marriage case just a few years ago. And then finally, King versus Burwell, which is known as the Obamacare case, just recently. In all of these cases, the Supreme Court has cited Marbury versus Madison in its role as having the power to say what the law is, having the power to interpret the Constitution, really being the final arbiter of constitutional questions. And without Marbury versus Madison, it wouldn't be clear that they had that power. So ultimately, that's why I say the most important Supreme Court case in history. And one last comment. If you go to the National Archives, some of the great documents are on display. Of course, you have the Bill of Rights, the Constitution, but the opinion of Marbury versus Madison is just right next to those. And that, I think, sort of highlights the importance of Marbury versus Madison. One of the great opinions of the case, one of the great documents of our government. And so, for that reason, really that the court established judicial review and has since that time invoked it over and over and over as the foundation of its power, is why I say that's the most important Supreme Court case in history. So, that's all I have. Does anybody have any questions?
This precedent of the court being the most important court in the land, is it like they gave it to themselves? Is it part of the opinion was made by them, right?
Yeah. You know what's interesting is that it doesn't say anywhere in the Constitution. It doesn't say that the Supreme Court has the power of judicial review. And so what's interesting is Marshall just announced that they had that power. And like I say, before that time, nobody, it wasn't clear that they had that power. The concept of judicial review had been introduced earlier. It was in one of the Federalist Papers. I think it was maybe 78. And so it was a concept that was out there, but it wasn't clear that the Supreme Court had that power. It wasn't in the Constitution, and it was just Marshall just announcing that yes, we have this power, that then became the basis for all these future decisions that I just cited going forward.
Could it be seen as a response to Jefferson and Madison with the Virginia and Kentucky resolutions, where they're claiming that the states have the right to declare laws unconstitutional?
Could be. That was part of the Virginia Kentucky resolutions. That Jefferson was part of. He's, like I said, he's a states' rights guy, and the political part is certainly part of it. One thing that's kind of interesting is that I think Marshall realizes, he doesn't want to upset the balance too much. He's got to factor in that he really is a Federalist. He's trying to rise above, but at the same time, he's trying to rise above politics. And so he doesn't want to get into sort of the political debate. Well, I'm going to side with the Federalists, and I'm going to, order Jefferson and Madison to deliver this commission. What the court does instead is strikes down the statute as unconstitutional, and in that way, they're sort of rising above the political debates, and they're kind of acting like a court at that point. Does that answer your question? One other comment that I'll make, I think is sort of interesting. Marshall could have easily tried to order Jefferson and Madison to deliver this commission, but I think at some level he might have realized, Jefferson was elected president, and so I'm not going to interfere with that too much, even though I might ultimately disagree with that. And I've heard that some people have said that, maybe that's what John Roberts was thinking when, in the Obamacare case, of course he ultimately sided on the side that would uphold Obamacare, but, maybe he was thinking, well, Obama was elected president, this is what he ran on, I'm not going to interfere with that and strike that down. So who knows if that's what he was actually thinking. It might be interesting to hear his take on that, but that was just one comment I just wanted to point out.
How is Marbury satisfied just for them to say, like, you deserve it, but you still don't get it? Like, how is he satisfied with that answer?
Yeah, well, it's true that he doesn't get his commission, so he doesn't get to take office. But at the same time, the court is saying, you're right. I mean, it's not like you're you don't have a basis for this case. You had the right to be upset. So they were acknowledging that right. It's true that he doesn't get to take office. So ultimately, he loses the case. But it is a consolation that the court says, you were right. So I think that's a consolation. He's not totally satisfied, but better than just outright loss.
Did Marbury have any kind of legal career after that?
I don't know if he did or not. I don't know the rest of the story on Marbury.
Just kind of goes off the grid there.
Has anybody looked into it being less about judicial review and more about the many cousins?
I think that was a factor. And that goes back to sort of the rivaling views that I talked about. Like Marshall was a nationalist. He was seen as a federalist. Of course, Jefferson was not. I don't think that it really came down to that. The fact that they're cousins, I think it just kind of made for an interesting dynamic to the case, but I don't think that really influenced the decision. Any last questions?
Okay, thanks a lot.
All right, well, thank you all for having me.
I don't know if you are up here often. There is a book at the library, and it discusses the Marbury versus Madison case, but specifically Marbury's side. I can't tell you exactly where to find it. I can tell you it's in the legal section of that.